All right, thank you. All right, everyone, I'm going to call the docket. When I call your name, please stand to let me know you are here. If you don't respond, then I will assume you are not here and a warrant may be issued for your arrest. In custody, we have Idulio Emmanuel Chewy. Oh, you're in bond? All right, so you're Idulio Chewy? I'm sorry? All right, thank you. Christopher Joe Medina. Okay. All right, if there's a Christopher Joe Medina in the courtroom, your attorney requested that your case be reset for April 11th, so we'll see you then. Casper Ayala is in custody. Stephen Miles, custody. Carlos Romero. Thank you. In custody, we have Jose Gonzalez. Tanisha Allison. Thank you. If there's a Jason Flores here, you need to be in impact court. We will let you know in just a moment. Jose Ruiz, custody. Jacob Garcia. Sean Branch is in custody. Pete Garcia. Robert Andrade. Jonathan Mendiola, if anyone's here for him, he's been sent to impact. Joseph Anzadua. Thank you. Carlos Salazar. Kevin Neuenfeld, if you're here, you need to be in impact. Ashley Caballero, you need to be in impact. Jose. Okay, help me pronounce that, Deputy Mejia. I'm sorry. Thank you. All right, Deputy Mejia, I'm disappointed. Valentin Frio is in impact court. James Montero. All right, where is he? Thank you. Charles Arnold. Thank you. Christopher Barode. Here. Steve Terrazas. Dakari Jackson. Here. Arturo Vara. Here. Luis Contreras is in custody and Tyler Small is in custody. Is there anyone who came in late or your name was not called? All right, over here, what's your name? I'm sorry, what?
That's my judgment. I believe it's already been dismissed.
All right, we'll have them check and see if it's been dismissed. Yes, sir. Thomas in the last name? All right. Have you spoken to your attorney? Who is your attorney? Okay. All right, you may have a seat. Yes, sir. First name? Last name? Have you spoken to your attorney? Do you know who your attorney is? All right, we're going to make sure that happens. You can have a seat. Yes.
Yes. Okay.
All right, do you know who your attorney is?
Yes. Good morning, Your Honor. I'm here for Jessica.
Oh, nice seeing you, Judge Lacey. Once a judge, always a judge. All right, everyone, these are the rules of the court. The files for criminal trial division is over here. The files for family violence is over here. Please just grab your file, place it on their table, have a seat. They will call you when they're ready to confer. It's a first come, first served basis. I do that so we can keep the center of the courtroom as least congested as possible. Please do not approach the court coordinator for a reset or continuance. I'm the only person who can give that to you. Do not approach the court unless you've conferred with your client and conferred with the state. If you have a client who does not speak English or English is not their native language, but it's your native language, we'll still need an interpreter be brought down, so request that. Once you requested an interpreter, please do not leave the courtroom because we have a shortage of interpreters. Unless it's jury trial, they're usually in court maybe 10, 15 minutes. All right, everyone, today is Tuesday. We're closer to Friday than we were yesterday. Let's be kind to everybody. And if you see someone who needs some patience, loan them some from your pockets. All right, everyone, please confer and let's have a good Tuesday.
Jason Flores, you need to go down to the second floor. We're waiting for you. Second floor, inside. Second floor of the building. Robert Valderas,
And Norma, if they have not seen their attorney and their attorneys in the building, see if their attorneys can be brought in so they can get their attorney's name and address. All right, Thomas Balderas, she's asking you to approach. And Norma, can you check to make sure that Valentin Ramos or Caroline, that Valentin Ramos has been dismissed?
yes.
Counsel didn't give me a case number.
Is
No, it is not.
that-
Yes. Valentin Ramos. Can you come forward, please? All right, if you can give the clerk your all right, your case has been dismissed. You are excused. Thank you. Thanks for showing up for court and dressing appropriately. All right, have a good one. Stay out of trouble, okay? All right, who's his attorney? All right, and is his case indicted or no? All right, if you'll give him the information. Yes.
Jessica Lopez,
Oh, okay. I'm sorry.
but that's you, oh, that's you.
I was gonna be like, well, don't give me a call from down there. Oh, thank you. Sure. Yeah, you're so awesome. Okay, well, you were, see, I saw behind the kitchen door and you had me going there when you said infested. I was like, thank you for saving my life. Caroline, I'll give that to you since they want to come down.
I think that's what I actually said. Because they were supposed to do it by 22nd. Yeah. But then they got like that, like. But like at least one of them got put down. Oh, I didn't hear about that. Well, it was. Oh, like that. I didn't say something. I love that. I still love that. Every once in a while, I still remember it. So, I was pretty good at that. So, yes, that's what.
Norma. We can coordinate with James Oakbridge in the jail in Guadalupe. And so maybe we can take care of that while they're in Guadalupe County. Hi, it's good seeing you. Yes, of course. All right, how you been doing? Oh, awesome. Thank you so much. I appreciate you guys agreeing to be mentors for the students. Yeah. I enjoy it. We're going to have to talk about you teaching. You'll enjoy it. It's very rewarding. No, they're nice. They're nice. Yeah. No, no, they're just trying. I always try to help them if they think they want to go in a specific profession before they spend lots of money and take out lots of loans. I want them to shadow somebody to see if it's something that they thought it would be. Because sometimes people just watch television and if you watch television, all lawyers do all day is go to lunch.
Yeah.
And that's what they're thinking. Oh, I get dressed up and I go to lunch. And it's like, no.
But we are gonna meet for coffee. But,
Okay.
after that, and it's just kind of get to know them and then we'll set up things and then start up and-
Okay, sure.
Maybe come with them.
Oh, awesome. And I know Norma was telling you that we don't set pre-trial, but if anytime you want to come in to have something set, you can just set it. Like if you all want to work out something before it's indicted, just have her set it and she'll bring it in. You're welcome. It's good seeing you. Have a good one.
Well, I guess it's fun to me, I do it. I'll talk to Bruce and then I'll talk to you. Yeah, it feels. Yeah, I think it's all. But they should. Yeah, exactly. They should.
Yes. Mhm. Well, I don't have the motion. And where's her attorney? I mean, her client? Where's her client? All right, Mr. Barode, if you could come forward, please. On the record, Your Honor? Yes, we're gonna go on the record. Christopher Barode, where are you? Thank you, Vashon. All right, come forward. All right, we're going to go on the record. Court is calling 2019 CR 7764 and 2023 CR 1857, State of Texas versus Christopher Barot. Could I have state announced, please?
Daniel Escobar for the state of Texas.
Are you Mr. Barot?
Yes, ma'am.
All right, your attorney
Yes,
has filed two motions to withdraw in your case. Have you had a chance to review those motions?
I haven't got a chance.
Thank you. Right, so normally, well, not normally, your attorney should be present to introduce this motion, but your attorney is not here. Do you have any objections to the court hearing this motion without your attorney being present?
Nothing other than,
No, I want you to listen to my question and only answer my question. Do you have any objection to us hearing this motion without your attorney being present?
Can you say it one more time? I'm sorry, man.
Do you have any objections to this hearing going forward without your attorney, Ms. Stacy Cross being present?
I have no objections, yeah.
All right, do you have any objection to her withdrawing from your case?
No objections, yeah.
All right, so I will state any objections.
No, Judge.
All right, so I'll grant the motion. She is no longer your attorney. Do you need an attorney appointed to you?
Yes, yeah.
All right, so just have a seat. We'll get an attorney appointed to you, okay?
Thank you.
All right, thank you. All right, and this person, if you can have an attorney appointed to him quickly, please. All right, thank you. Wow. Thank you very much. But what if it's still infested?
I'll let you know.
Yeah. Hello, Ms. Metzel. How's it going?
This morning.
Oh, it is. It's like,
Walking to the library.
oh, it is. But you know what's going to end up happening? Because we're taking our recess at 12, my prediction is that 11:45, everybody's going to come in. Saying, we have things to do.
I feel like that's accurate. Appreciate it.
All right, you're welcome.
To you guys. Feels like it.
No, I just can't see people who think they're looking for everyone. No, witness. This is not in. He's looking everywhere.
Usually it's this one.
Nobody has one. Yeah.
All right, thank you.
Here is. So. As well. Will you take the animals?
Diana, okay?
Yeah, she just had something.
Oh, she had something. To say. Okay. Are you gonna be here for the trial this
No.
afternoon?
Yes, for the
Correct,
trial,
okay.
and she'll be back tomorrow.
Okay, it's nice to meet you. I'm Jason Jorgens.
Jason, are you?
I am, last I checked, yeah.
Okay.
Uh,
Oh, yeah, the one, okay, I got you.
Okay.
It's nice to meet you too. Did I hear you say you're gonna break at noon today?
Oh, yes, we're gonna take our recess at noon and then jury trial will start at 1:30.
Here's you're a big Grease fan.
Yes.
I live there.
Oh,
Yeah,
wow.
both my parents are Greek.
Oh, that is so awesome. No, I love it. And I was telling someone, I traveled to different places, but that is the best Greek salad I've ever had.
Oh, well,
There's
sure.
something about the tomatoes. And so they were telling me the way they grow them differently, not, traveling at the vine, but in the circles. They were telling me it's something to do with that and the volcanic.
Well, all the vegetables and fruit over there are much better than your island.
No, I mean, it's true. And then the seafood, because I'm from Louisiana, so I love seafood. And no, Shreveport. But I told them that you can actually taste the sea. And, in the seafood. And when we went to a restaurant, we're like, oh, we're going to order this. They're like, no, we need to see what's coming in on the boat. I'm like, I love this restaurant. So it's 100% fresh. And you can just really taste the difference. Like it hasn't been processed, doesn't taste like there's hormones
Hasn't
that have
been
been put in.
frozen.
No, it hasn't been frozen. So I just had the most fabulous time there. I'm gonna try to convince my mom to go because the water there, I was telling someone, the way it looks in postcards where it's that blue and it is exactly like that. Oh gosh, it's beautiful. I so enjoy.
On Santorini, is it Ionia, little area? Did you go there?
No,
There's a
we
little restaurant and it overlooks.
ended up going to Mykonos and I just wanted to do Mykonos because I love the sound of it. And then,
You're saying it very good.
oh, thank you. And then I don't know if that's the place where they have the restaurant named after Jackie O.
Sure.
So we went there and then there were some places that people decided they wanted to go. But I was like, no, I'm just gonna sit and enjoy the water and look out over the, watch the birds. And so it was just awesome.
So my mother is from an island called Chios. It's
Mhm.
not a touristy island. It's the closest island to Turkey. And yeah, it's actually in the Bible, but and my dad was from Sparta.
Oh, wow.
Yeah.
It was just awesome. And then, here in the United States, we always tear things down. So I'd love to go when you see things and it's not torn down. It's just beautiful.
You go to the villages. You
Yes.
travel like that, good.
Yes.
That's the way to really get.
Oh, it is. So it's just like, oh, I love it.
Yeah.
Yeah. Oh, thank you so much. Okay, did you get any for yourself? Oh, because I took yours. But I'm definitely gonna have to go back.
Well, I hope your mother goes.
Oh, I'm gonna convince her to go. The way I can convince her to go is I'll tell her, well, I'm gonna go by myself. She'll be like, no, I need to be there to protect you. So,
And if you don't care too much about the beach, I think October is like the cheapest time to go. And it's still more, warm enough. You might have to wear a sweater.
well, I will tell you, we ended up in Scotland in October.
Oh, was it cold?
Oh, yeah, it was cold.
Okay, I've never.
Yeah. Oh, but it was still beautiful. And the person there told me we need to come back during the summertime because they say all of the mountains will just be in bloom with heather, purple and yellow heather. He's like, it's beautiful. But we saw the coos. They don't say cows. Coos, hopefully I'm saying it correctly. Some of the most beautiful coos I've seen. Like their hair looks like they had a stylist because it just grazes their eyes. But
They
they,
understand them.
yes.
You could understand.
I will say it took probably like a day because you have to get used to the rhythm, but it was awesome. I enjoyed that too. But still, my most favorite place is still Paris. That's my happy place. But I always say, if I could not, my first place to live would be Paris. And then it would be someplace in Greece, because I absolutely loved Greece. I didn't think I would fall in love with it so much, but I did. And then my next place, believe it or not, would probably be maybe Venice or Rome. I like Venice. And it's just beautiful, just sit. But all places are great when you're not working. You just pretend like you're super wealthy. You just, no job, no bill to answer.
Paris, but I didn't like the people.
Oh, okay.
Yeah.
Yes, what?
So let me know.
Mhm.
And they have the little museum.
Okay,
I don't know if you've seen a picture of it.
all right, then let's do that.
I didn't like that modern. You know, for.
Okay, that's fine. Oh,
He sticks out like a sword.
is John coming? Okay, yes, let's do that.
Comparatively, with the architecture. No, that's fine.
And London, the only thing about London is definitely too expensive.
I've never been to London.
Oh, gosh, even if you're pretending like you're wealthy because you're on vacation, it's still too expensive. We ended up at a hotel and we're like, yeah, we need to grab those food coupons. But that's, believe it or not, I think I went there maybe 4 years ago because I don't even like pizza. I got to become one with pizza. It's either,
Because of the food, it's not something.
oh no, the food was great, but it's extremely expensive. London is not for the poor or the middle class. I mean, it's expensive.
Before all this mess, I always wanted to go to Russia.
Ah.
History, but
I have a couple of friends who've gone there. And so the other thing that's sort of on my bucket list is I want to do Morocco. I've never been. So I want to do that. I want to do Egypt.
that's be a great place to go to.
Yes. And I've seen some of that on House Hunters International. It just looks so beautiful.
It's like the up and coming, my daughter and son-in-law are going this summer.
Oh, wow. Okay, I'm gonna have to do that. All right, who's here on James Montero? And I'll let you, when we're on the record, I'll call the style of the case. All right, where's James Montero? All right. When he comes up, we'll take the matter up.
Yeah.
Yes. Hi, good morning. I'm sorry, what? Okay, all right, thank you. What other case? Yes. See. All right, the party's on James Montero. All right, Mr. Montero, thanks for dressing appropriately for court. All right, so where are we on this case?
We have extended an offer to counsel. It does kind of play on the misdemeanor. So we've yet to reach that. So if I can compare the misdemeanor court.
All right, which misdemeanor court is this?
County Court 7.
All right, have you gone to County Court 7 and see when they can set this?
I checked in with them this morning because we are set on misdemeanor 2 days as well, and so I'm gonna go down there for the setting to see when they have an available date for us.
All right, so what is happening on the misdemeanor setting today?
It was just a check-in. They're aware the felony is pending, and so they wanted to make sure that this case was moving.
All right, so if you will go to County Court 7, then come back and let me know what the status is. And if they are resetting it, have them reset it for April 24th.
24th.
No later than that, if possible. And then we will, and then once you go down there, just come back here and then we'll see about a reset.
Okay.
All right, thank you.
Thank you.
All right, could I see the officer, please? Who's the officer on the warrants? Thank you. Thank you. Hi, if you can come around this way, please. See, my glasses are just for distance, not for reading.
I have the LASIK.
Like,
Oh my gosh, so LASIK can go well for you?
No, it did. It's just, they tell you that.
one of my judges.
I know, it's just- and then you have 40-something.
Oh my gosh, see, I don't want to be that person who does LASIK and then it doesn't turn out right. Hmm. There is still that chance, right?
Yes, yes.
See, she has them up here.
All right, there's that one, and let me just sign the other one. There you are.
Thank you.
You're welcome. Have a good day.
Have a good Easter.
You too.
Court is a lot.
That's not to say that that's the way it seems.
Yeah. Since I was 12 years old. Photos. And everything. And then it's 5 years.
I'm like, what's that? You just felt we can do that. The one area of the country did it. Yeah. One from the end that, when I went to school, everybody was on. And so, I'm buying insurance. And you can- just log in between 5 to- In their scoping and so by the end of it, you have all that on the race. Now, by the end of it, 6, This is the speed I had.
For the parties on Steve Terrasas.
Yeah, so he's.
Let me just find him on the docket. Okay. All right, thanks for being on time. You said you would not be late again, and you have not been. All right, so what's happening with this case?
Going to the statement and offer today, and I've spoken briefly with Steve about it, but I know that we need some time to talk to this family. Grow and answer a lot of different questions.
All right, do you have all the discovery?
At this point, I believe I do, Judge.
All right, so I need an acknowledgement of discovery done. How old are you?
1.
So, Ms. Ferguson, I need a reset for this. Let's reset it in 3 weeks. That's gonna be your plea deadline date. Does it give you enough time to discuss everything? Okay.
Very well.
All right, so April 25th is gonna be your plea deadline date. At that time, you need to let me know whether you're accepting or rejecting the plea. If nothing is worked out on that date, then the court will not consider any plea bargain agreements with that good cause. Otherwise, you have to plea open to the court. Do you understand? All right. Do you have any questions about anything about the process? All right, so we will bring you back on April 25th. Ms. Ferguson will give you a reset form and then you are excused.
Thank you, Judge.
All right, thank you. And counsel, if you'll sign the acknowledgement of discovery before you leave.
Yes, ma'am.
All right, thank you.
Yes.
And Caroline, on this one, they're gonna reapproach when he comes back from county court. Oh. You're welcome. All right, the party's on Carlos Salazar. All right, thanks for dressing appropriately for court. All right, so what is happening with Mr. Salazar's case?
Judge, this is our first setting. I'm gonna set up an appointment with Mr. Salazar to review the video discovery on the case. And then we should have an idea of where the case is gonna progress.
All right, Mr. Salazar, you doing okay? All right, Ms. Ferguson, can I have a 30-day reset for Mr. Salazar? All right, so Mr. Salazar, we're gonna be back on May 9th. At that time, we'll make sure you have all the discovery and state you need to be prepared to make an offer on that date.
Yes, Your Honor.
All right, is there anything else that you need, Mr. Salazar? Any questions about the process? All right, thank you, Mr. Salazar. After you sign the reset form, you're excused. You're welcome. Who's here on Robert Andrade? Yes. Okay. Sure. Here you are. Thank you. Oh, and that one's done. All right, are you here on Andrade?
Yes, Your Honor.
All right, if y'all can come forward, please.
Sorry for stepping out, Your Honor.
No problem. All right, Mr. Andrade, you were late for court today. Why?
I couldn't find a parking. I just got here when the last two names you were calling.
All right, you gotta include that in your time, okay? All right, so today was his, well, I put that the plea deadline date had expired. Is there going to be a jury trial for this case?
I believe so, Your Honor.
All right, Mr. Andrade, your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand? All right, how long do y'all expect this jury trial to last?
I expect it to last 4 days. now.
4 days? Is there video?
No, Your Honor, but there's extensive evidence that we have to prove up on.
All right, so I need an acknowledgement. Well, I have the acknowledgement of discovery. Is there any updated discovery?
I don't
I believe so either, Your Honor.
All right, Ms. Ferguson, I need a jury trial date for Mr. Andrade. They say 4 days. I think it's going to take more like 3. All right, so April 17th, and Ms. Ferguson will give you a reset form.
Thanks, Judge.
Thank you. And Mr. Andrade, thanks for addressing appropriately for court. Delio Chewy. All right, so what's happening with this case?
Judge, we are conferring on the NTR. He has a new case as well. We are missing discovery on that and we don't have the drug labs back. We'd like some opportunity, if we could get a 30-day reset, Judge. Want to talk to his family, talk to him a little bit more, see if we can get a little more of the discovery in and come back at that time.
All right, so here's the thing, we've already had a previous reset.
This
So-
is,
Yes. So here's my question. State, these drug labs, it takes a while. I mean, are you really gonna have drug labs on this case within 30 days?
I don't know, Judge, this case occurred, the new case probably about 2 weeks ago, so there's a good chance that we would miss the back by then.
All right,
Judge, I just got on the case, so there may have been a reset that I just wasn't aware of.
so it appears then, without that number one, then we're looking at his not reporting for many months, allegedly, since 2020.
Yes, Judge, he was arrested on a warrant, so that is accurate. Judge, I think we can work this out. I needed just a little bit more time so I can talk with his family. If you would just let us have one more reset, I think we could probably resolve the whole thing on that next day.
All right, Mr. Chewy, when you drug tested today, what are the results gonna be? All right, so he's gonna do a drug test today. And Ms. Ferguson, on this case, recall this and, let me see.
Judge, he would request if we could get a drug patch so he can be monitored and show that he's clean while he's plating.
Okay. All right, Ms. Ferguson. We can either recall this, can we do it at the end of the month? What date?
So Judge, that last week, I'm on vacation. Can we do it the first week of May?
All right, Ms. Ferguson. Are we able to do it in the first week in May?
May 4th, Judge.
All right. We'll be back on May 4th. And there's going to be a drug test today.
And Judge, can you order a drug patch?
Sure, they'll give him a drug patch. A drug patch is going to cost more. But that drug patch, you're only going to have it if you're negative today. You understand? They can't do a drug patch.
We can't even volunteer. What about as a requirement for his bond, Judge?
But it won't be through probation though.
But we could order it so he could, pretrial officer could get him set up with one?
Because what is his bond set at? Does anyone know? All right, I'll order pretrial services to do a drug patch. So Ms. Ferguson, can I get a B page? All right, so we'll be back on that date. And at that time, the court will go forward with the hearing and whatever, if there's not discovery on the new number one, then the court will not be hearing the new number one. It will just be on the other alleged violations.
Yes, Your Honor.
All right, thank you.
Thank you.
Oh, you're welcome. Who is here on Arturo Vara?
Good morning, Judge.
Good morning. Mr. Vara, if you come forward.
Yeah.
All right. The court doesn't have the acknowledgement of discovery in this case, so I need the acknowledgement of discovery. And so we're here for motions.
1 second, Judge, let me pull up my file. No, Judge, I think we just for status on Mr. Vada's case last time in February. We had set up for trial. The judge asked us to come back today just for an update to see if we made any ground on any possible plea agreements. And the answer is we have not. I believe we have a trial date of May. Mr. Vada's case.
It's actually May 30th, and May 30th is actually your plea deadline date and your jury trial date.
Okay.
But the court shows it on the docket, at least the coordinator put this on the docket, that there are some motions that need to be heard. Are there motions?
I see a motion to reveal agreements with any witnesses.
There's a motion that I filed back, Judge, when Mr. Brummer was the prosecutor handling this case. I don't believe we ever approached the court regarding those motions, but most of them were agreed, they weren't contested.
All right.
Follow up with Jason Garahan on it and update the court.
Well, I mean, since we're here for motions today, if you all confirm your motions, see what you can agree to, and then
Sure.
we'll place those on the record.
Yes, sir.
All right. All right, so just have a seat.
Thank you.
And Caroline, on bar, can you pull the defense's motions? Thank you. Luis Patrick Contreras is the attorney.
Present, Judge.
Okay,
Be up in the next, I'm talking to you, bro, I'm calling.
okay. Oh, it's you. All right, on this case, this is actually his plea deadline date, and it was set for jury trial. I showed that his plea deadline date has previously expired. Is there anything that's going to be worked out in this case, or it's jury trial?
I don't believe so, Judge. My client has indicated to me that he wants a jury trial.
All right, Mr. Contreras, your plea deadline date has expired. State, how long do you anticipate this case will go?
I'm trying to find the case, Judge. Give me a
It's
minute.
on the recall docket.
Oh,
It's aggravated robbery.
3 or 4 days, Judge.
All right. So it'll probably be more like 3 days unless they're 13-hour videos. Are there any long videos?
No, Judge.
Okay. So Norma, I need a jury trial date for Mr. Contreras, 3 days. All right, your jury trial date is June 13th, Mr. Contreras. You'll be brought over to court dressed in whatever civilian clothing you have at the jail. If you wish to appear in something else, then you need to let your attorney know. Counsel, if there's an issue with the clothing exchange, let me know and we'll see what we can do to help expedite that.
Yes, Ron.
The court has an acknowledgement of discovery that's been signed. Is there anything else that needs to be taken up with this case, counsel?
Nothing, defense counsel.
All right, thank you. All right, Jose Gonzalez.
Present, Judge, is in custody.
All right, so this is scheduled for jury trial. Is this case going to be worked out or not?
Judge, I was talking to Mr. Garahan, he's still talking to the decedent's family to see where they're at as far as any possible plea agreements. And that's what I was told, Judge.
All right, so how long are you expecting this trial to be?
I would say, Judge, about 4 days.
Okay. Any videos?
There's videos, yes.
Okay. All right, so Ms. Ferguson, this is a murder trial, so they're telling me about 4 days, and we're in a jury trial setting. And Mr. Gonzalez, we will be taking up your trial today, but we're currently in another murder trial, okay? We can't do anything sooner than August 15th. August is the earliest date, but I tell you what we'll do. Ms. Ferguson. We're gonna set you in June. It may not go in June because they're telling me really it's in August. So I'm gonna give you a June date, and that June date will be your jury trial date and plea deadline date. And so we'll see where we are at that time, but counsel, it's probably not gonna go in June because there are other murder cases that are older than yours that are gonna be going before that, okay? All right, what date in June, Ms. Ferguson? All right, so we're gonna put you down for June 13th. And that'll be your plea deadline date, and I'll just put it in the system as a plea deadline date and motions.
What's wrong?
And I'll make a notation on my file that if both parties are ready for trial at that time, then it will also be a trial date, but that'll just be on my docket sheet. All right, so they're gonna bring you over, Ms. Ferguson, I'm still gonna want him brought over dressed. They're gonna bring you over dressed. You're gonna be dressed in whatever civilian clothing you have at the jail. So if it's something that you don't want to be attired in, you need to speak to your attorney, sign a clothing exchange. If there's an issue with the clothing exchange, let the court know.
What's wrong?
Is there anything else?
Not from defense counsel, Judge.
All right, any motions that I need to hear?
No, Your Honor.
All right, I need an acknowledgement of discovery state.
Okay, Judge. For just the murder case or for all the cases?
The murder case. Well, actually for all cases, because I don't know if this is going to be a used in punishment if it comes to that or not.
Okay, Judge.
All right, is there anything else?
Not from defense counsel.
All right, thank you, thank you.
You should turn this off.
All right, are the parties here in Guevara? I'm sorry, Vara.
Junior or senior?
Uh, Gabina.
There, well, you have junior and senior.
Well, the only thing I have on this that says Gabina Vara.
There you go. That's probably my judge. Yes, he's here.
I like your suit.
Thank you, Judge.
If you were president, though, that would cause an uproar.
Oh, that's right. There was a president, yes, a few years ago. People that care about things that are unimportant, I guess, made us think about it, so.
All right, so on this one, the defense is here. They filed a motion Your motion, find your motion.
We had requested, this is a case where a few weeks ago, the state had announced not ready for trial after 4 years, and we had, my client is simply asking at this time to have the leg monitor taken off. It's my understanding that it wasn't had any violations or anything. You had been kind enough to change it to a partial tracking, I think, at some point, but now we're just requesting that it come all the way off. And in the meantime, I have filed a motion for speedy trial.
Okay, so let me see. Caroline, do you have the motions for Mr. Vara, Gavino Vara? It's the 2019 CR 11408 case. He filed a motion to alter and amend conditions of bond. And just 1 second, let me see.
I haven't filed a new motion, Judge. I came by yesterday just with a B page to talk to you, but I can file a motion if you need.
Do you have any objections to proceeding without a motion?
No, we can proceed with that.
Okay,
Thank you.
and then the other one is, what other motion you said?
Well, a speedy trial, but we can hear that some other time. But I did file it,
And so what I can tell you.
unless you want to grant it and make them dismiss it right now. That would be great.
All right, what I can tell you is that the previous order that I had with regards, before we go on the record, the previous order that I granted with regards to GPS was tracking only, but it was tracking with a curfew. And his curfew was from 7 a.m. to 7 p.m. with an exception for work. And he was only to be out until 9 p.m. with proof of work. So, all right, we're gonna go on the record. Court is calling 2019 CR 11408, State of Texas versus Gavina Vara. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
John Finn's for Mr. Vada.
Right, and if you all could slide a little,
I'm up against this. I don't want
they didn't put it there right. Deputy, you can tell when Deputy Laura's not present. Oh, thank you,
There you go.
John.
There you go.
You're doing double duty. All right, and then you're cut off. I don't see you. There you go. You're so tall. There you go.
Judge. I'm gonna have to, I'll get on my knees.
All right, and are you Mr. Brown? All right, so we are here on an oral motion to alter and amend conditions of bond. State any objection to proceeding on the oral motion?
No objections to proceed on the floor.
All right, so off the record, the court had previously ordered or granted a motion to alter and amend conditions of bond to include tracking only, but it was tracking only with a curfew. Okay, all right, defense, you may proceed.
Sure, Judge. As I mentioned off the record, a few weeks ago, we were here on a trial setting and the state announced not ready on a case that's a 2019 indictment. Obviously, we're in 2023, so it's been 4 years. And the state told you on the record that they hadn't talked to any witnesses. They didn't have any of their witnesses lined up before trial, anything like that. The case was continued over our objection. And at this time, we're simply asking for the court to remove the leg monitor condition from his leg altogether. Not only does he have to pay the monthly fees, but also just the inconvenience of having a leg monitor is a problem. And so we would request that he not be mandated to have any sort of monitoring device on him.
All right, state.
And Your Honor, is correct, the state did ask for a motion for continuance, but that was denied, as the court's well aware of. And we proceeded on another case up to trial, so that's the reason that it was continued. And then just to verify, and I don't know, I don't have the actual violation, but in our system, it says that there was a tamper alert back on March 21st, 2021. So I don't know if that was ever addressed, but that is something that was just concerning to the state and wanted to present it to the court to be aware of it.
Right.
Judge, real quickly, I misspoke. My client tells me that he does not pay for it. So it's free of charge at this time.
All right, so here's, and the state is just telling me about this chapter alert. So is there any objection to either side to just having it as tracking? I know you'll have your objections, but state, do you have any objections to just having tracking?
No, Your Honor.
And defense, what is your objection to tracking? And let me give you the date. All right, the date that the court made the order for the tracking only with the curfew was in, I think, February. So defense, what is your objection to just having tracking only?
Well, obviously, it's a step in the right direction, Judge. However, we would request that he not be burdened with such a thing. I feel like at this point in time, since the state has not proceeded to trial in a timely manner, that he is continuing to, he is innocent until he's presumed innocent until found guilty. And at this point, he's being unnecessarily burdened with having a leg monitor. I don't want to wear a leg monitor. I'm sure most people don't. And just the encumbrance of having one altogether, I think, is a problem. My client, the violation that was mentioned, if I heard Mr. Garahan correctly, it was 25 months ago, over 2 years ago, and with no further violations. So I'm not really sure what point is served by the court or the community in having him wear this leg monitor at this time. Moreover, as I pointed out, I think the state has kind of forfeited their right to have any sort of monitoring device on him when they announced not ready for trial a few weeks ago.
All right. And do you have any objections to my asking your client any questions that are related to this leg monitor issue?
No, that's fine, Judge.
All right, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you speak up so the court reporter can hear. Could you state your name for the record?
Gabino Vivara,
All right, and can you spell your name?
G-A-V as in Victor, I-N-O, and then Vara, V-A-R-A.
All right, so with regards to the GPS, what have you not been able to do because you were on GPS?
I haven't been able to get a good job. I work at one spot. I'm a carpenter. I do construction. I haven't been able to go to like different jobs because they say I gotta be on one spot all the time.
Okay, and what else?
Just like I said, I don't have to, I haven't had to report, thank God, to the monitor, but just what do you call it? It's annoying to have it on my leg when I have my boots on and everything. You know, I'm saying I can't take them off. I gotta have a hard time taking them off. Just annoying.
All right, any other questions?
No, Judge.
All right, Mr. Barr, I heard your concerns and I don't believe I'm the court that originally put you on the GPS monitor. There's another judge who did that. Because before I give conditions, I like to hear facts about everything. And sometimes people will do maybe a knee-jerk reaction. I don't know, because I wasn't there, and GPS everybody. But you're currently on GPS. The state has said that at one point there may or may not have been a tampering. I don't know if I'm the court who heard that. So this is what I'm going to do. You say you have issues with going to different jobs. I am just going to make it tracking with no curfew. So you don't have any curfew. You're just going to be on tracking. So to tell us where you are, not me, because I'm not the tracking specialist. It will tell somebody else where you are. So the only concern that you'll need to be bothered with is making sure that it's charged. And counsel, if there's an issue outside of that with the GPS, let the court know. Motions, if there are pretrial violations, those are usually, well, not usually, those are sent to the clerk, coordinator, and myself. So it'll come across my desk before it comes across anyone else's desk, okay? So that's what we'll do. Your jury trial is scheduled for August 1st. Counsel, that's the earliest we can get him in. But if something changes or happen, counsel, if you want to keep checking in with the state to see, because sometimes, as you know, cases move off the docket and we can get him in earlier, we will do that.
Okay, I appreciate it, Judge. Thank you.
So I put that on there for tracking only, and if you need a copy of it.
Thank you, Your Honor.
Thank you.
All right, thank you.
Thank
If you can make him a copy. Oh, let me add one thing to that. Okay. Yeah, just if you could write agreed at the top. Yeah. Who is here on Dakari Jackson?
Here, Judge.
I should have guessed. We're gonna have you have your own office like Mr. Cox has his own office in the back. He may want to charge you for that. All right, where's Dakari? All right, thanks for coming in on time and dressing appropriately for court. All right, so we're here. It's just been recalled for today because council wasn't able to be here yesterday. So where are we on discovery with this case?
Your Honor, I conferred with the state this morning. They're gonna talk to the complainant's mother. In this case, we do have all discovery that's been provided through the Deferred County Discovery System. There's a couple of pictures that Brittany notified me that I need to go and pick up, but I believe I have everything the state has in my possession.
All right, so Ms. Fergus, can I have a 30-day reset on Jackson? And we'll put it as discovery to make sure you have all the discovery and state on that date, you need to be prepared to make an offer.
May 2nd.
All right, we'll come back on May 2nd.
Yes, Your Honor.
All right, thank you. Who is here on? Oh, this one's done. And Norma, can you make sure Jorge Canales is here? Yes. Okay, awesome. Yes, he's excused. And tell him, thank him for his honesty. That's rare. Yes. Yes. Okay, I just have it right now. It's on the slide.
If I put it on my back.
Yes.
This isn't a matter of touching on,
I thought you were gonna say this is a matter of grave importance.
this is a matter of importance.
I just, give me just 1 second, let me make sure I sign this and then I will take your matter out. All right, Brittany, all of it has been signed.
Thank you, Judge.
You're welcome. Yes.
Your Honor, you have an ongoing trial that's currently proceeding today.
Yes.
And one of the witnesses, I am her attorney in separate legal criminal matter.
Mhm.
And I am, she has requested me to consult with if she's going to be called to trial. She's at the jail.
Okay.
And I'd like to get it.
Oh, yeah.
And I don't want to put it on my voucher because it's technically, not.
Oh, no, I always, all attorneys who are appointed. And they're coming in to represent witnesses.
Okay.
Yes.
And, because everybody's been talking to me about it and, but I've just been told that she will be called. So,
All right.
probably tomorrow. So,
I think the way things are going, we may get to her today.
I think you have my cell, but I'll leave my cell because I'm done for the day in court. And I'll just be at my office. But I don't think she's here.
What is the time announcement for you to get here once you're called?
Parking, probably 15 minutes.
Okay.
Just to get here. I'm not that far, but get space and come in.
I mean, who are you representing?
Miranda Garcia.
Okay.
So,
Yeah.
and I have already been meeting with her about this issue because of this contact.
Okay, we'll see you then.
Let me see if she's here. Because if she's not here, I think they may. I know how these go, sometimes especially.
No problem.
But it's not.
All this is.
Well, I guess I wanted to be specific.
Okay.
Hello, good morning. All right, do you wish to take this back to Judge Mesa since she signed the previous ones?
She's gonna be this today, so.
I'm pretty busy today as well. I understand that I am the presiding judge.
Yes, Your Honor.
All right, so if you'll take this to Judge Mesa and let her court coordinator know that she's previously signed it. And then if there's an issue, you can bring it back. I'm here till 5. All right, you're welcome. All right, who's here on Carlos Romero?
Judge, I am. Bridget Garza. Ms. Romero.
All right, so what is happening with this case? Okay, is everyone could please whisper?
Judge, we're ready for trial.
Okay. All right, so Mr. Romero, your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plea open to the court. Do you understand? All right, the court has the acknowledgement of discovery. Any pretrial motions that need to be heard?
Not at this time.
All right, how long do y'all expect this jury trial to last?
Days, Your Honor, probably 2-3 days.
Mhm.
I mean, of course, punishment, if we did that, I don't know if they're gonna order the judge or the court or the jury.
All right, Ms. Ferguson, I need a jury trial date for this. They're telling me 3 to 4 days. So it's probably 3 days. Or maybe 2. All right, June 13th is your jury trial date. All right, thank you, Ms. Ferguson. We'll give you a reset form and then your excuse. Thanks for dressing appropriately for court.
Judge, we have, we'd like to request some adjustments with his monitor. Do we need to file a formal motion?
If the state has no objection to proceeding on it orally, we can proceed on that. Have you all conferred on that?
No, I haven't.
All right, if you all confer on the monitor. Okay, thank you. Jason Anzaldua or Anzaldua?
Good morning, Judge Neil Calvis on behalf of this.
All right, and you're on this side.
My bad. I was trying to take the state of take the role of the state, and dismiss my own case. That didn't work out quite right.
So we're here because the state, at the last setting, the state was to speak to the complainant on the burglary of the habitation force. And then the state was supposed to make an offer.
So Judge, we did find there is an assault pregnant person case that was filed at large with our office. It does look like the paperwork going through on that. So that's gonna be invited soon. It looks like the paperwork was generated, I think, March 28th. So that should be coming down pretty quick. So then that's probably also going to be something that takes precedence.
All right, and I'm assuming that's on a different date. Alleged,
Yes,
okay.
Judge.
All right, Ms. Ferguson, can I have a 30-day reset on Anzaldua, please? All right, we're gonna come back on May 2nd and state if you can make sure that the defense has the discovery on that new case.
Yes, Judge.
And are you gonna be hired on the new case?
Yes, ma'am.
Okay. Is there anything else for me to sign?
No, ma'am.
All right, thank you, Ms. Ferguson. We'll give you a reset form.
Thank you.
Always good seeing you, Mr. County.
You too. It's always a pleasure.
Yeah.
Well, most always a pleasure. See?
All right, have a good one.
See, Judge.
The law school days still are popping up with you, okay?
That was not fair. Every day except that one.
Just for that one. And Norman, that will be a discovery date. And was that Joseph Anzadua? Okay. I didn't want to get him confused with. Well, let me ask you this, why do I have Anzadua for jury trial on May 7th, or April 17th? Okay, all right, thank you.
I don't know.
Did Robert Andrade make his appearance? Okay. All right, thank you. All right, Tyler Small.
Present on that, Judge.
All right, if Mr. Small, if you could come down, please. And this is family violence. All right, what's happening with this case?
Sir, we have tendered an offer to counsel, which I believe they're going to be rejecting.
All right, did you get the CPS records and jail calls?
Judge, I do have the both of those.
All right, so I need an acknowledgement of discovery done today.
I'll get that and get it signed.
All right, and then Ms. Ferguson, can I have a 2-week reset for a plea deadline date? All right, April 18th. You need to let the court know whether or not you're accepting the offer or not. After that date, the court will not consider any plea bargain agreements. And that will also be a jury trial date as well. You understand? All right, thank you.
Judge, can I also touch one matter? If the court would consider reducing his bond, he's been in custody since the offense date. The only prior arrest history that he has is for misdemeanor DWI, and I believe a criminal mischief.
All right, follow your motion and the court will hear it.
I will. Thank you, Judge.
All right, thank you. Jacob Garcia.
He's present, counsel.
All right, Mr. Garcia, thanks for dressing appropriately for court. So this is scheduled for jury trial today, but we're currently in a jury trial. So I can't be in 2 places at the same time.
Yes, Your Honor, we understand.
Maybe I could, but I don't know if the other parties can. So how long is this trial going to take?
Probably about 4 days.
Agreed.
All right, are there videos?
Yes.
How long are the videos?
Hours.
Oh, not 13 hours? That's
Probably
the,
like
oh, okay. Then it's probably gonna take 2 days. All right, Ms. Ferguson, I need a jury trial date. It's family violence.
June 6th.
All right, June 6th is your jury trial date. Your plea deadline date has expired. The court will not accept any plea bargaining agreements without good cause. Otherwise, you have to plead open to the court. Do you understand? All right, and I need an acknowledgement of discovery before you all leave.
Okay. Thank you, Judge.
You're welcome.
And my client be excused, I'll stay into the acknowledgement.
Yes, once he signs the reset form. And Norma, do we have the attorney for the road yet? Okay. Well, find him so that we can take this matter up. And who's the person in at the, I don't know, the haircut? The, what do you call that, where your hair is short in front and long in the back? What was that from the 70s? Oh, mullet. Yes. Why are you here in shorts? You, sir, with the mullet. Yes, you. What is your name? Jacob what? Are you on the docket today? All right, so in court, you're not allowed to wear shorts. You understand? How old are you? All right, so when you show up to court, if you come back to court, do not wear shorts, okay? And who's with you? I'm sure your grandpa and your grandmother told you how to dress and you ignored them. So I'm telling you, you will not wear shorts in court again. You understand? All right, thank you. Thank you, grandmother and grandfather. Sometimes they listen to strangers. So what is a Marbach? Oh, okay. I thought you said Marbach because somebody was telling me there's a new hairstyle called the Marbach. Okay. All right, I didn't know. I try to educate myself on what the children are doing these days. And a lot of times what they're doing is, we've already done it before. And they act like it's new.
With our witness. I'm sorry, I guess we can come back. Right before. Yes, I just want to make sure. He requested.
He's on bond, yeah.
You want to bring him up here?
Okay, I just want to make.
Yes, I think all witnesses may already be present.
Oh, yeah.
Mhm. So you can talk to the deputy.
I don't know why.
Yes, you may. What's going on? Ah, thank you. All right, thank you. All right, who is here on Jose Aguiana? Are both of you all in this case?
I am your honor.
Okay. All right, if you have your client approach, please. And I'm going to depend on you to help me pronounce well, you're here. How do you pronounce your last name?
Aguinaga. Aguinaga.
Aguinaga.
Aguinaga.
Aguinaga. Close enough. You just like, I give up. All right. All right, court is calling 2023 CR 1856, State of Texas versus Jose Clemente Agua.
Aguinaga.
Yes, that's what we're calling. All right, could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Megan Enriquez for Jose Aguinaga.
All right, and are you Jose Aguinagua?
Jose Clemente Aguinaga.
All right. All right, and do you mind if I call you Jose Clemente?
That's fine.
All right, and because I'm being informal with you, you can just call me Judge Stephanie, because I can't pronounce your last name. I promise you I'm going to work on that, though. All right, counsel, have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Jose Clemente, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, Your Honor.
Next, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
I'm next going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're being charged with the offense of driving while intoxicated third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason I do not follow your plea and give you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I believe he does.
Do you believe he's currently competent, was legally sane at the time of the offense?
I believe he is.
Mr. Jose Clemente, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor. Anyone
Anyone promised you anything other than the plea? You're satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it, and did you sign it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 3 years in the prison. There's a $600 fine. There are no applications for deferred adjudication. The state recommends community supervision. There's to be ignition interlock for half the term, DWI intervention course VIP, and driver's license suspension for 1 year. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Next, I'm showing you what's entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation and 150 hours community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
State offers State's Exhibit 1 in all attachments.
No objection.
All right, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
All right, and State, you may confer. Did you understand again that that you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Briefly, I believe that he will be successful in this probation and do anything that the court asks of him. He has a supportive wife, 3 young teenage daughters. A good job. His wife also is employed, and so he realizes his mistake driving that night, and he is prepared to do anything the court asks of him on probation, and I do fully expect he'll be successful.
All right, anything you wish to add?
Your Honor.
All right, do you understand how dangerous it is to drink and drive?
Yes, Your Honor.
I always tell people, just get a designated driver or take the bus. I mean, and sometimes taking the bus, that can be dangerous because you're intoxicated. You may get hit on the way to the bus stop by somebody else who's intoxicated, or because you're walking in a roadway. This is your 3rd DWI, which tells me you have an alcohol problem, but it appears that he does great on probation. I realized that one of your DWIs was a jury trial, and the jury, I guess, ended up finding him guilty from what I could see. But you're one of the people on the planet who just should not be drinking at all. You understand?
Yes.
So I understand that you were at a friend's house and then you were drinking.
Bachelor's party. Yes.
So was everybody drinking? I mean, they're not going to get in trouble because this happened in 2022. And if nobody has arrested them on their way home, then this is where we are. So was there a lot of drinking at the party?
Yes.
All right, and let me just tell you the reason why I asked that. The reason why I asked that is because if everybody was drinking at the party, I understand that people were not being in their right mind. But if your friends were not drinking at the party and you were drinking and they let you drive after drinking, then that's not your friend. But if everybody was drinking, then maybe their thought processes were clouded and you can maybe give them the benefit of the doubt. But you need to tell your friends that you are one of those people on the planet who cannot drink alcohol at all. You understand?
Yes, Your Honor.
And if they don't respect that, or if they say, hey, just have a little, it's just going to be one, then that's not your friend because they should be helping you with your sobriety. All right, this is what the court is going to do. The court is going to sentence you to 3 years in the prison, suspended and probated for 3 years. There's a $600 fine that will be probated. Ignition interlock for half the term. DWI intervention course. DWI education course. The VIP 1-year driver's license suspension. 150 hours of community service restitution. How old are your daughters?
15 and 17.
All right, so whenever you think about drinking, you know what you need to think about? You need to think about that if your daughters, because I'm sure your 17-year-old may be driving right now, they could end up she's going to get her license at some point. And the 15-year-old is going to ask for her permit at some point, or either they're going to be in car, going to prom or whatever. And somebody could be driving intoxicated and end up hitting them, and you would be devastated. So, but for this happening with the officer pulling it over, you could have been that person who ended up hitting someone, because this is around Christmas time, who was out just trying to shop for, I don't want to spoil it for the children, who was out trying to make sure that Santa Claus knew where to go. You understand?
Yes, Your Honor.
So don't be that person who comes to court and you're crying because you ended up hitting somebody, injuring somebody, or killing somebody. You understand?
Yes, Your Honor.
All right, so I'm going to do 150 hours of community service restitution. I'm going to require parenting classes with Triple P. Once he completes the parenting classes, the community service hours will be satisfied. Proof of employment within 15 days. No employment as a home health care provider with minors. There's to be regular reporting by Zoom or in person. Probation, I'll do field visits for 2 months. If everything is okay with field visits and you want to discontinue them, you can discontinue them. And if you want those field visits to count for his reporting during those 2 months, you may do so. I'm going to want a TAP evaluation. Follow the TAP recommendations. However, if TAP recommends inpatient treatment, we'll start with intensive outpatient treatment. And I'm going to want 90 sober meetings in 90 days. All right, probation, is there anything else he needs? Yes, regular UAs, and make sure they test for alcohol. Anything else? Is there anything else you need from the court in order to be successful on this probation? All right, for this court, communication with probation is key. If there's an issue, talk to probation. If you feel like that issue is not being addressed, just come to court. We're here Monday through Friday. showing you what's entitled trial court certification of defendants' rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. Do better, okay?
Thank you.
You're welcome. Who's here on Pete Garcia?
Your Honor,
Yes, and where's Mr. Garcia?
all I can say is he's not here.
Okay, all right. Court is calling 2022 CR 6930, State of Texas versus Pete Garcia. Could I have parties announced for the record for the state,
Jason Jorgens for the state.
for the defense?
Lorraine Efron.
All right, this hearing was called at 9 a.m. It is now 11:21 a.m. Mr. Garcia has not made an appearance. Defense, have you had contact with your client?
Your Honor, all I can say is he's not here. That's all I can say.
All right, I appreciate you saying that for the record, Ms. Efron. All right, state.
Your Honor, the state moves for a bond forfeiture.
All right, that will be granted. If your client, and the court will remain your client without bond. If your client makes an appearance, the court will reconsider. All right, thank you.
Thank you.
Ma'am, what's your name again?
Lorraine Efron.
I got it. Okay, thanks, ma'am. Thank you.
Ms. Garza, are you ready?
Yes, Judge, may I reapproach on Carlos Romero?
Yes.
I have conferred with the state
Mhm.
and they are opposed to the removal of the monitor.
Okay.
We're willing to go forward without the red flag.
All right. Court is calling 2021 CR 5583, State of Texas versus Carlos Romero. Could I have parties announced for the record for the state,
Jason Garrett, Your Honor.
defense?
Bridget Garza.
And are you Carlos Romero?
Yes, ma'am.
All right, defense is requesting the removal of the GPS device. They're requesting it orally. Any objections to the motion not being in writing state?
No objection.
All right, defense.
Mr. Romero, what day did you get released?
Let me swear him in.
Oh, I'm sorry.
That's okay. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Ma'am.
All right, you can lower your hand.
Mr. Romero, what day did you get released from custody on this offense?
On 25,
What year?
2022.
And so you've been on full house arrest since that date?
Yes, ma'am.
Okay. And have you had any violations on the monitor since that date?
No, ma'am.
Okay. And you've been reporting on time to every court appearance with in the 187th District Court?
Yes, ma'am.
Have you ever been late to court? Okay. And where are you living?
I stay at my grandma's,
And what address is that?
6726 Harbor Field.
Okay. And who else who else resides in that household?
Stay with a younger cousin and my.
I didn't hear you, sir.
With my younger cousin and my grandma.
And what is his name?
Michael.
Michael.
Venegas.
And Michael Venegas, he's the one that gives you a right to court when you have court? Okay. And the last time that we were in court, I asked you that you were gonna be set for specifically for trial. You may be up for trial already, is that correct?
Yes, ma'am.
Okay, and you asked permission to go to a certain store to buy court attire for court?
Yes, ma'am.
Okay, and how much time did they give you to leave the house to go buy a suit?
They allowed me 3 hours. For every suit.
And was that sufficient time for you to go buy the suit? Did you have to rush? Was that enough time?
No, I had to rush. I wanted to get a button down and everything. I couldn't. I had to grab a suit. Go home.
Okay.
All right, and for the record, he's dressed appropriately. I think that suit looks great.
Thank you.
Sure.
And what was the bond amount that you posted in order to get released from jail in this case?
The burglary bond was at 65,000.
Okay. Prior to that, you had been in custody on another charge. Okay, what was that charge?
capital murder.
Okay, and on that capital murder charge, how long had you been in custody already on that case?
I was incarcerated since October 2020,
And a total of how many months?
27 months.
27 months. And then that case was rejected, is that correct?
Yes, ma'am.
Okay. And on this case here, you bonded out. What was the bond on this case?
$65,000.
Okay. And the monitor fees for this, those fees are being waived.
Correct.
Okay, and so you're still paying the bonding company because they bonded you out on this case.
Correct.
So you still owe the bonding company some money.
Correct.
And because you're on full house arrest, you're unable to work.
Right.
Okay. And if you were to get released, do you have any job leads?
Yes, ma'am.
Okay, and what would they be?
I have multiple options. I used to work for a movie company before I got incarcerated. So it's just a matter of going up there and speaking to Jason, the boss. But I've had previous encounters with tip agencies throughout San Antonio. So like with those agencies, you just have to call them, update your information, and you should be able to work with them.
So you can go back to the moving agency or you can go back to the temp agency.
Correct.
And the main reason why you want to work is because, why, can you tell the court that?
I just want to move forward with life. I don't want this to prohibit what I got going. And it takes money to invest money. It takes money to just live. You know, I can't eat what I want. I can't do what I want. To just get toothpaste from HEB, I have to put it in order and get it delivered the next day. I pay $6.99. It's just too much hassles to be on full house mom.
And you don't have funds because you're not working.
Correct.
And so you're asking the court to, are you asking the court to remove the full monitor or for the minimum to get, allow you to go to work and then come back? Partial monitor or the tracking?
I would honestly want it completely removed, but seeing as I came so far, I would take tracking, partial, anything, just so I could do something like this.
All right. State, do you have any objection to a curfew with tracking?
I guess partial GPS, Your Honor. We're we don't have anything opposed to that. Although if we want some argument about possible employment, the state doesn't have a position.
Well, with what I can tell you, I'll hear the argument on employment, but I'm not going to let him have an employment where it's movement to different places as the mover, because that could result in him being in the vicinity of the complainant's location. So if there's some other employment that is not employment that's non-stationary, then the court will consider it. But as far as being a mover, yes.
That basically sends you to the warehouse. She asked me if I had multiple options, so I just brought it up. But
Okay.
With that being said, like, no, it's fine. I could go to the warehouse and be there the whole day. Give y'all a set schedule and come home. That's
All right, State, would you have any objection to that?
no.
All right, if you all want to step back then and discuss curfew hours and of course, include in the location that he is not to be in.
The victim in the case.
Yeah.
is dead.
I'm a little
Oh.
confused about that.
Okay.
Okay.
Okay, well, that explains it. So if you all want to see what you all can agree with, the court will consider it. All right, who's here on Tanisha Ollison or Ollison? All right, if council could approach. Good morning. And probation, this is for deferred adjudication. Court is calling 2022 CR 10664, State of Texas versus Tanisha Ollison. Can I have parties announced for the record for the state defense?
Leo Gonzalez, Tanisha Ollison.
And are you Miss Ollison?
Yes.
Could you restate your name?
Yes.
Leo Gonzalez.
Thank you. Okay. All right, and you're Miss Ollison?
Yes.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Ollison, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it?
Yes.
And did you sign it?
Yes.
I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Proceeding as to lesser charge of count two, assault bodily injury, married co-ed.
Any objection?
No objections, Your Honor.
Showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand what you're charged with is assault, bodily injury, married, or cohabitation as a Class A misdemeanor?
Yes, Your Honor.
The range of punishment for that offense is anywhere up to a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to $4,000 fine and up to 1 year in the Bexar County Jail?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Ellison, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, no,
Has anyone promised you anything other than the plea?
no, no, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on the charge of assault, bodily injury, married, cohabitation as a Class A misdemeanor. There's a $500 fine. State recommends deferred adjudication, and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the entirety of your plea? Defense?
That is correct, Your Honor.
State.
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, there are not, Your Honor.
Next, I'm showing you outside the plea bargaining agreement. The state is requesting that your deferred adjudication be for a term of 9 months. There's 60 hours of community service restitution, no harm for injurious contact with Melvin Olison, batterers intervention prevention program, anger management, and $100 donation to the battered women's shelter. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense of assault, bodily injury, married, cohabitation as a Class A misdemeanor. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offers States Exhibit 1 in all objections.
No objection, Your Honor.
Ms. Olson, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same.
Yes, Your Honor.
All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding guilt as you applied for deferred adjudication. Is the complainant here today?
And it's not in possession.
All right, before I enter a sentence and do this no harmful or injurious contact with Melvin Ullison, I'm gonna need to speak with him. So, Ms. Ullison, are you still living with him?
No, I live with my mom.
All right, so I can sentence her today, counsel, and then she comes back. And then I'll make a decision on Mr. Ullison having no harmful or injurious contact because I have concerns. Do you have any children with Mr. Ullison?
Yes, ma'am.
All right. Have you been seeing your children since this?
Yes, my daughter. She stays with me.
Okay. Is that the only child you have with him?
Yes, ma'am.
All right. Do you have any other children?
No, ma'am.
All right. So have you had, are you all communicating for exchange of children?
No, ma'am, not as right now. Other no contact order.
All right. And so does your mom facilitate that or does he not see the daughter?
You don't see my daughter at this time.
Is there a reason for that?
No, he just.
Doesn't? Okay. All right. So this is what the court will do. The court will sentence you to 9 months deferred adjudication. There's an affirmative finding of family violence. There's a $500 fine that will be probated. Are you employed?
Yes, ma'am. Our Baptist Medical Center downtown with CNA.
All right. Proof of employment. Within 30 days. I normally don't allow people to work in the medical field, but the state has reduced this to a misdemeanor. So there's to be proof of employment within 30 days. There's to be no contact with Melvin Ullison. The BIPP course. Is there a reason you want BIPP and also anger management?
Based on the allegations, there was another incident that included in this, filing of a felony.
Okay. How old is your daughter?
She's 3 years old.
Okay. So was Child Protective Services involved or no?
No, ma'am.
All right. I'm going to ask for no contact with Melvin Ullison, the BIPP course, 60 community service restitution hours. I'm going to order parenting classes. Once you complete the parenting classes, then the 60 hours will be deemed to be satisfied.
Yes.
There's going to be anger management course as well. There's to be regular reporting by Zoom or in person. I'm going to want field visits 1 time per month until further notice. Probation, you can count the field visits as her reporting if you all want to. Okay, I can't see that far. My glasses off. I see the smile. Okay. And there's to be regular UAs. Probation, is there anything else she needs?
No, Your Honor.
Is there anything you need from the court in order to be successful? Showing you what's entitled, oh, you want to go around? Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, you can go off the record. You have a 3-year-old. You're gonna have to learn how to communicate more. I know that tensions can run high when you're being served with an eviction notice and whether or not you think the eviction notice is correct or not. And then maybe you have a partner who maybe you think we wouldn't have this eviction notice if you would hold up your end of what you're supposed to be doing. But violence is never the answer. You just remove yourself from the situation, not hit somebody with a cell phone, okay? All right, good luck to you. You're welcome. Yes. Sure. Okay, so I'm gonna have to write this where it will make sense to Caroline. Could I get another B page?
Sorry, Judge.
Oh, that's okay. It's on 2021 CR 5583. Because if I send this over there, they'll say like, what is it? All right, if you want to give that to Caroline and she will make an order. I mean, she'll make a copy for you. And Caroline, if you could include that with that. Because that should be stapled with that. Yes. Who's here on Stephen Miles?
Are we free to go?
Yes.
Okay.
After he signs the reset, you're free. All right. So counsel, you have all the discovery?
As far as I know, I do.
All right, and so an offer was already tendered. Is this going to jury trial?
Yes, I believe so.
All right, state, how long do you expect this trial to last?
3 days.
All right, and are you proceeding on both cases or just one?
We'll proceed on, well, we would like to proceed on both.
Okay.
Make sure we file the gender.
All right, so Ms. Ferguson, I need a jury trial. It's family violence. And they're telling me maybe 3 days. All right, your jury trial date will be June 6th.
For family violence?
Yes, this is a family violence case.
No. For.
It's indecency with a job.
Yeah, family violence handles those cases.
That's their care. That's-
All right. So you said June 11th, Ms. Ferguson?
6th. I thought you-
Okay. All right. And Ms. Ferguson, for some reason, I have this as a recall date for April 11th. So can you make sure June 6th is in the system? All right. So your jury trial is going to be June 6th. You'll be brought over in whatever civilian clothing you have at the jail. If you wish to be attired in something differently, you'll have to sign a clothing exchange for your attorney. Counsel, if there's an issue with the clothing exchange, let the court know.
Judge, respectfully, I thought Mr. Miles was coming over today and he's, cause I filed a letter for him to be brought over in his regular civilian clothes, and I think he has some clothes brought over. So I'm not too sure where that's at in the.
Oh, we're in a jury trial.
I'm talking about his clothes and everything, so this process doesn't have to be redone because that already has been done.
No, I mean, just check with them and make sure, check with the jail and make sure that there are no issues. Because if whatever clothing you have at the jail, if there's some clothing that your attorney did as a clothing exchange, where clothing was given to him and it was exchanged, then you will be brought over in that.
Okay.
Because they don't allow you to have 2 sets of clothing at the jail. But if someone perhaps made a mistake and there are 2 sets of clothing at the jail, they're going to put you in whatever.
I'm
Okay.
not sure why, do you know why he wasn't brought over today in his clothes?
Because we're in jury trial.
How did they know that?
They know that. Yes, we have to request that somebody be brought over and dressed for trial.
Well, just kind of, I'm just trying to understand why is his date keep getting kicked down the road?
Because we're in a jury trial.
Well, he's been in jail for over like, what, 10 months, 11 months?
We're currently in a jury trial. We're in a murder trial. So that's
Understand.
why And this murder trial that we're in started last week. So that's why we're still here.
Because we got a new prosecutor now. mean,
Well, I think the prosecutors will tell you, the fact that there's a new prosecutor, that doesn't factor into any situation with the court. Everybody is ready for trial, then we'll go to trial. But I can't do two trials at the same time.
Well, I respect the judge. I know you said the date of June sixth, but Mr. Miles would like a date as soon as possible. June sixth is as soon as possible. That's
Fine.
fine.
So, Mr. Mouse, this is the way it works. I know you think your case is the oldest case, but it's not the oldest case. So we're bringing you back on June sixth. And on June sixth, if there's a case that's older than yours, that case is going. And you know how you know that case is going? Because that person will be brought over dressed for trial and you will not be dressed for trial. I'm only one person. Could I really do two trials at once? Yes, no, I really could. I've done that before. But we don't have a separate courtroom for me to do that. So that is why your case is not going to trial. And trust me, I've been a defense attorney, I've been a prosecutor, and as a defense attorney, I know when I have clients who want their trial heard right away. But there are other people who have been at the jail longer than you, and their cases are going before yours. So it doesn't matter if your attorney is ready or the state is ready. If there's an older case, it's going before yours. Do you have any questions about anything? All right, thank you so much.
So June sixth is the earliest we can get a date.
Yeah. All right, who's here on, let me see. Sean Branch?
President, Your Honor.
Yes. All right, what is happening with Mr. Branch?
You want him brought up, Judge?
Yes. All right, so the last thing we had the cell phone that was downloaded.
The discovery.
Yes, and I've signed the discovery acknowledgement.
Yes,
So has an offer been tendered?
Yes.
it's been tendered to me, Judge. I'll discuss it with the defendant before the plea date for the deadline date.
All right, Ms. Fergus, can I have a plea deadline date for Mr. Branch? Can you set it in 3 weeks? All right, April 18th will be your plea deadline date. And it also, yes, April 18th. And that also may turn into your jury trial date as well. You understand? All right, thank you.
Come this way.
Yes. Because on the partial. Okay. Okay, do you have a whiteout? All right, who's here on Charles Arnold? All right, Charles Arnold. And probation, this is an application. Court is calling 2023 CR 1864, State of Texas versus Charles Arnold. If I could have parties approach and announce for the record for the state.
Ruben Herrera for the state.
Defense.
Daniel Miller's arguing for the defendant.
Okay, are you okay?
Yeah, the gate just caught my ankle.
Okay,
Not be rough.
all right. And are you Mr. Arnold?
Yes, ma'am.
Counsel, you received all the discovery and did you review it with your client?
Yes, Your Honor, I have.
Court will find that the state is in compliance with discovery. Mr. Arnold, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am. Yes, ma'am. Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Mr. Arnold, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am. Yes, ma'am.
All right. Did you understand you're charged with assault family second?
Yes.
That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
None that were viable, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Arnold, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state recommends deferred adjudication. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea?
Yes, ma'am.
State?
Yeah.
Defense?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
None were necessary, Judge. So no.
Next, I'm showing you outside the agreement. The state is requesting that your deferred adjudication be for a term of 6 years, 200 hours of community service restitution, no harmful contact with Maria Moore, no alcohol consumption, TAP evaluation, and follow recommendations in the BIPP course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
State on Exhibit 1 and all attachments.
No objection.
Mr. Arnold, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Is he still living with the complainant?
He is, Your Honor, and what he's telling me is that he now works at the Southwest Electrical. He works on contracts with HEB. He says that and he's proffered to me that they have a peaceful relationship now. I think that as you read in the report,
that night he was under the influence of alcohol, which he admits is or was a problem.
Let me stop you, counsel. So is Ms. Moore here? Oh, is she present?
I don't think she's here. Oh, she is.
All right, if she can come forward, please.
Oh, she is
And if
there.
he can step back.
I didn't know that was her.
No, no problem. If you can move over to this way. Okay. Okay, but the deputy's there, so that's why I put him over there. All right, are you Miss Moore?
Yes, I am.
Could you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Could you state your name for the record?
Maria Jeanette Moore.
All right, Miss Moore. Are you and Mr. Arnold still living together?
He lives on the property. He was staying at my mom's, but she has always a phone, so he's back on the property, but he stays in the RV in the back.
All right, so he's not living in the house with you? Okay, all right, so so both parties can know, this is what the court is thinking about doing. He can live on the property, but I'm not gonna actually have him living with you until he has worked on his sobriety and started the violence classes. Are you okay with that?
Where's the balance class?
Oh, he takes a batterers intervention program. It's to help with any anger issues.
Yes.
So do you feel comfortable with that? Otherwise, I can have him off the property.
He's doing okay. He's trying not to drink and stuff, but I feel that he does need like not to go to jail, but to have that.
Oh, no, I'm going to give him
and so he
some
doesn't-
treatment.
Because he has that, the only time he's violent is when he drinks.
Okay.
Otherwise, he's like the perfect man. I can go on and tell you how great he is.
Okay, but my question is, are you okay with him staying on the property? But I'm not going to allow him to stay physically with you at your residence
Yes.
until he shows me that he's clean and sober. And until he takes some, it's called battery intervention program.
Yes.
But I want him to have some classes under there so he can deal with whatever anger issues he has. And then counsel, after a certain time period, you can always come back to me and see if I'll consider removing that. So he will be allowed to stay on the property if that's okay with you,
That's okay with me.
but he will not be able to reside at your location. All right, so do you understand?
Yes.
All right, so if something were to happen between both of you where you decide to let him stay at your location or call him to come over and stay, it's not going to impact you, but it's going to impact his probation with me because I'm going to tell him not to do that, okay? All right, is there anything else that you feel I need to know?
No, I think that's.
All right, any questions from either side?
Well, Judge, I would just like to clarify, is this a no harmful or injurious contact order with, I guess, for lack of a better term, no contact with the main residence?
Yes, there's to be no contact at the main residence. He's not allowed to reside with her. But I understand that he lives on the property and at a separate location on the property.
Yeah, I have an
That's what-
RV.
Yes.
So that's where he's staying at.
And that's what my understanding is, that's what they've done in order to comply with the court's no contact orders at the time. So I guess that's been sufficient. And so I guess
Well,
from now on,
if we were just to do a no harmful or injurious contact, that means that he would be allowed to stay at the residence, and I'm not going to allow
I
that. So I'm
understand.
going to put that in the order.
yes,
Okay,
okay, perfect. And then I don't have any other questions. I don't know if we did that.
all right, thank you. So I want to make sure that you understand he is not allowed to stay at your residence. So he will be allowed to stay in the RV. Probation, he can stay in the RV, but he's not to stay at her residence. And he's not to be shouting at her and being disrespectful.
About bank accounts and stuff like that. Is that what you-
Well, I mean, if they have joint bank accounts, they have joint bank accounts. He's not allowed to live at the residence.
Yes, ma'am. So just so, because I think and I'm still a little, I just want to clarify, a little confused. So
Oh,
like,
I'm going to make a clarification. We're going to go we're still on the record. I'm going to make a clarification in my order. So is there any other questions for this witness state?
No, Your Honor.
Defense?
No, you're right.
All right, thank you so much for coming now.
Thank you.
All right, the court is going to place you on 6 years deferred adjudication.
Yeah, you just, no, you're good.
defendant is not allowed to reside with Maria Moore. So I think that clears everything up. He cannot reside with her.
Okay, I understand.
All right.
Thank you.
There's an affirmative finding of family violence. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. I'm going to want 90 sober meetings in 90 days. The BIPP course. I'm going to want a TAP evaluation. Probation, if the TAP evaluation recommends inpatient, I want to start with outpatient treatment and make it intensive outpatient treatment.
Thank you, Your Honor.
You are not allowed to drink alcohol when you're on probation. It doesn't matter whether you have an alcohol problem or not. It's just one of the rules and it's not allowed. I'm going to want regular UAs and please test for alcohol. There'll be 200 hours of community service restitution. In lieu of the 200 hours community service restitution, once you complete the 90 meetings in 90 days, give him an hour for every sober meeting he attends. And that's after the 90 days. I'm going to want field visits one time per month until further notice. Regular reporting by Zoom or in person. And probation, you can count the field visit as his reporting if you so choose. Probation, is there anything else he needs? Is there anything else you need from the court? Defense, state? All right, just 1 second. Showing you what's entitled, excuse me, sir, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? All right, because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, just remain in the courtroom. We're going to take up the victim impact in just a moment.
Off the record, you're correct.
Yes.
I thought we're doing.
Are we ready on Christopher Barode or no?
Oh.
Are you ready on Christopher Barode?
Well, Your Honor, no, but if we want to, no, I think I'm gonna ask the court to reset only because he has a pending number one, but I gotta find out what he wants to do with the offer. So,
All right,
can I
so-
do that real quick?
Yes. Who's here on Fernando Trujillo? Yes, what is the issue?
Judge, this gentleman is set for on your Thursday's docket.
Mhm.
He is currently in federal custody down in Carson City on a multi-count indictment. Direct count. And so I'm just trying to avoid having to come to court on Thursday since he's not going to be here.
All right, do you know what the federal charges are?
I believe it's drugs. It's multiple defendants, Judge.
All right, Ms. Ferguson, can I have a 45-day reset on Mr. Trujillo?
And I will be gone all of,
Okay,
so it could be in June.
well, let's set it mid-June.
I'll come back and tell you about it.
Okay,
That's fine.
all right, we'll come back on June 20th. Where are you headed?
Egypt.
Oh, wow, please tell me about your trip.
Thank you.
Yes. Who's here on Angel Gonzalez?
Good morning, Judge.
Yes.
I had conferred earlier with Brittany,
Mhm.
Judge. He had been set, I believe it was last week when I was actually in a capital murder trial
Yes.
in Comal County. And then it ended up being set on
April
April
10th,
10th.
yes.
For a trial setting, but we were going to ask the court if I could come on the 11th. I had a vacation planned and prepaid. And I
Oh, where are
won't be
you
back.
going?
I am taking my mother's been very ill and we are going to Mark.
Okay, that's gonna be awesome. Okay, I can't interfere with you spending time with mom. All right, so April 11th?
Just, yes, but we would ask that that be not a trial setting, but a set, can't remember what you call it, but where they give me an offer because I hadn't gotten one yet.
Okay.
And so I'd like to, and of course, I don't want him, it's a murder case, so I'm sure that, it's not anything that I'd want him to make a decision in a single day on.
Okay. All right, Ms. Ferguson, can you put this for April 11th? And be prepared to tender an offer on that day.
And we understood that we would be reset after that to a trial setting. Judge.
Yes,
Thank you so much.
you're welcome. Okay, why do I still have the file on Carlos Romero? I think that's done. Okay, and that's done. All right, Arturo Vara.
Present, Judge.
All right, court is calling 2019 CR 12034, State of Texas versus Arturo Vara. Can I have parties announced for the record for the state?
Jason Jorgens for the state.
Defense?
Linus for the defendant.
All right, so we're here for motions. Your jury trial is actually scheduled on May 30th. So the first motion is disclosure of Rule 702 witnesses and any facts or data relied upon by witnesses.
Your Honor, in regards to that, the state is in agreement, except for specifically item number 3, facts and data as the basis for reports. We just request a modifier that is limited to facts and data in the state's possession.
Any objections?
No objection from defense counsel, Judge.
All right. And counsel, for some reason, I do not have an order attached to this, so I'll write internally. So number 1 is agreed, number 2 is agreed, number 3 is agreed with the agree correction. All right, defendant's request for notice of extraneous offenses. That's something that you've requested it.
Yes, Judge.
Okay. All right, and the defense has filed a motion electing the jury for punishment.
That's correct, Judge.
Any agreements? States, you need to reveal those agreements. Defendant's motion to require the prosecution to reveal any agreement with the witness.
Yes, Your Honor.
All right.
We're in agreement on that.
Motion for evidence favorable to the defendant, agreed?
With one qualification, Judge, item 3 in that request is a move to require the prosecution to reveal its entire file to the court and to order the prosecution to determine if any prosecution witness has knowledge of any evidence. That would just be an in-camera inspection, I believe, for work product. The rest of our file is already available to the defense. But if the defense is seeking any work product, we just request an in-camera inspection.
All right, so I'll add with the exception of work product, which is to be viewed in camera.
Yes, Your Honor.
All right, and then we have the defendant's motion requesting notice of prosecution's intent to use certified copies of official written instruments.
And so, Judge, we're in agreement on that. The only qualification that we would request is they were requesting 30 days notice prior to trial. we'd ask that be modified to reasonable notice prior to trial. Because they're specifically, I'm sorry, they're not requesting notice, they're requesting actual copies. The copies that they're referring to are judgments, which are public records already available to the defense. So we just request that it be reasonable notice because we're not sure when we will actually obtain the certified copies of the judgments.
Defense?
Judge, I'm just requesting notice of their intent to use certified copies. I'm not asking for the actual certified copies, and then they'll provide them, I guess, if we get to punishment.
All right, state. He's asking for intent to use, and whether or not you have them or whether or not you use them, that would be something different.
That's fine. That's not what his motion says, but if that's what he's requesting now, then we're happy to provide notice. His motion is requesting copies.
Well, it says moves the court to require the prosecution to give the defense notice of its intent to offer into evidence certified copies of official written instruments, including but not limited to certified copies of any prior judgments of convictions of the defendant, which the prosecution intends to use as direct or impeaching evidence.
Yes, Your Honor. And in his prayer, he's asking for copies of such documents 30 days prior to trial.
All right, then your next sentence, counsel says the defendant requests that he be provided with copies of any such certified records at least 30 days prior to trial. Would you agree to it saying that you be provided certified copies once in state's possession?
Yes, Your Honor.
State?
That's fine, Judge.
All right, and then defendant's motion for disclosure of Rule 702 witnesses. I think did we just do that one?
That was the first one.
All right, is there anything else?
I believe there's also a request for discovery and Brady material.
That's correct, Judge.
Okay. And state, it's Brady. If it's Brady, it has to be turned over.
That's true, Judge, but the motion is broader, or the request is broader than simply Brady and 3914. Specifically, item number 8 is related.
I don't have that. Yes, I don't have that motion before me. And then anyone else that's not ready, the court is taking our recess because we have jury trials starting up at 1:30.
And then this request for discovery.
Counsel, if I could see your copy real quick,
Yes, Your Honor.
and then we can still search. Thank you. All right. So what is the issue with defendant's request state?
So with regards to item number 8, the defense is requesting copies of the criminal history of the witnesses and law enforcement officers in relation to this case. We are not allowed to turn over copies to the defense. Any criminal histories that we run will be made available to the defense. But I believe we're limited under the law and what we can turn over.
And that is correct.
It's fine, Judge.
With regards to item number 13, the defense is requesting copies of demonstrative evidence 20 days in advance of trial. That would include things such as PowerPoints and graphs, which based on the way it's described, would probably include like a voir dire presentation. Most of those aren't prepared until a day or two before trial. So we'd request just reasonable notice before or reasonable time to review before presenting such demonstrative evidence.
All right, which number?
Item 13, Judge.
All right, any objections?
No objection from the defense counsel.
And lastly, Judge,
Yes.
with regards to item 15, we request that to be limited to the scope of 702, 703, and 705, specifically notice of expert witnesses 20 days in advance of trial. The defense already has constructive notice of lay witnesses. We're happy to provide reasonable notice of any other lay witnesses.
And that's number 15?
Yes, Your Honor.
All right. Defense?
That's fine, Judge. But 20 days is fine.
All right, so then it's 20 days before the date of trial. Anything else from either side?
No, Your Honor.
All right, with regards to then 1 through 7 are agreed to. 8 is agreed to with the exception that the state will allow the defense to view the criminal history that is at issue.
Yes, Your Honor.
And I wouldn't say not at issue. Any criminal history, the defense will be allowed to view, but you will not receive copies. 9 is agreed to. 10 through 12 are agreed to. 13 is agreed to with the addition of reasonable notice from the state. 14 is agreed to. 15 is agreed to, but with the addition of 20 days instead of 30 days. Is that correct from all parties?
We're requesting 20 days notice of expert witnesses, since that's within the limits of 702.
I put down 20 days. Are you guys agreed to that or no?
Yes, Your Honor, 20 days for expert witnesses.
Okay. All right. Is there any other motions?
Not from the defense counsel, Judge.
Not from the state judge.
All right. Thank you.
Thank you, Judge.
Thank you. Always a pleasure seeing you guys.
Thank you, Judge.
You're welcome. Jose Ruiz. All right, so Mr. Ruiz, today is your plea deadline date. Are you accepting the plea or not?
No.
All right, so how long do you expect this trial to last?
This trial could be 2 weeks.
We haven't even, sorry, we haven't gotten our discovery yet. We just, some of it's being downloaded today.
We have Ms. Efron, who is hopefully the secretary, provided me with a drive. And it just finished. It's approximately 726 gigs of material that I've given to the defense today.
All right, Ms. Ferguson. I want this recalled for next week to make sure everybody has their discovery. What date? All right, so that will be April 12th.
Thank you. May I be excused?
Yes. On Barode.
Yes, Your Honor, I talked to him, I presented the offer. Did I bring him in?
Yes.
Yeah.
And then you're excused. There's nothing else that needs to be on the record, so we'll be back at 1:30 for jury trial.
Are we starting with opening statements?
No, we're in the middle of trial, so that it's going to start with the witness.
Witness, okay.
Yes. Thank you.
And can I ask the clerks for some information on the case? I don't think.
Sure. What do you need?
I just need the style and that's it, and who the attorneys are. Thank you.
And if you could hand that back after you finish, and then they'll give you the bar numbers of the attorneys and the attorneys.
Or I can get those when I get back.
Okay, sure. All right, so yes, counsel.
Yes, Your Honor, there's a new number 1 then just motion revoke some stuff in Travis as well. I've conferred with Mr. Escobar. He presented an offer to me, presented it to my client. He does not want to do that. So what I believe he'd like to do, correct me if I'm wrong, sir, but he'd like to contest the motion, Judge.
All right. Ms. Ferguson, I need a contested hearing on Barrow, please. Yes. Just to give him time.
And Judge, and if we had the offer, and it's nothing on the state, they didn't have the notice, but really, I could have just done it today if we had it, just so you know. For next
Okay.
time, but so it's short recess.
Oh, short recess. You
Whatever.
guys want to do this next week?
That's great. Is that okay with you?
Judge, I just need to reach out to the. I know it's been said a couple times, so.
All right, then let's do this. Let's set it in 2 weeks. Is that enough notice for everyone?
Thanks, Judge, just.
All right, Ms. Ferguson, reset this in 2 weeks. All right, April 17th.
Let's render. Yes, Judge.
All right, thank you.
Thank you, Your Honor.
All right, Ms. Ferguson, we'll give you a reset form.
That's great.
All right, and then there is victim impact.
Oh, yes, I'm ready whenever you are.
Are you all ready for victim impact? And we'll be back at 1:30 to start trial.